including the calling of its witnesses who were examined, cross-examined by counsel for the Deputy President, and re-examined. As the House adjourned, I directed that, as contained in the hearing program in this matter, of the determination of the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EDH, Deputy President of the Republic of Kenya. On resumption at 2:30 p.m., the Senate will hear the case of the Deputy President for 2 hours, comprising examination in chief and re-examination, while the National
Sasa
Assembly
ameshajenerate
will
hii
have
vitu
a
saa ngapi
period
bana?
of 1
Kuna watu
hour
wanafanya
and
kazi mbio.
55 minutes.
Imagine hiyo kitu ishajeneratiwa na ni more than 10 pages.
When the Senate resumed at 2:30 p.m., when the opportunity came for the Deputy President's side to commence its case, Senior Counsel Paul Mwita, counsel for the Deputy President, informed the Senate that he did not know the whereabouts of his client and sought to be allowed a little time to establish where he was. Thereafter, he informed the Senate that he had learned that his client had been taken ill. Asked how he proposed that the Senate proceed, counsel for the Deputy President requested for time, possibly up to 5 p.m., to try to meet his client before advising on the way forward. Counsel for the National Assembly, when asked to comment on the circumstances, argued that unfortunate as the situation was, this being a constitutionally time-bound process, it was imperative that pursuant to 11 of Part 1 of the second schedule to the Senate standing orders, the proceedings proceed. Now I'll read Rule 11. It provides thus. When the National Assembly or the Deputy President chooses not to appear before the Senate, that fact shall be put on record, and the Senate shall proceed with its investigations without further reference to the National Assembly or the Deputy President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the Deputy President. Now, honorable senators, it is also noteworthy that Rule 12 provides as follows. Subject to these rules, the hearing of the evidence, once it commences, shall proceed and continue until the Senate concludes the hearing of the matter. Following the representation made by counsel for the parties, I suspended the proceedings of the Senate up to 5 p.m. to allow counsel for the Deputy President to report the status of his client. When the sitting of the Senate resumed at 5 p.m., Senior Counsel Paul Mwite informed the Senate that indeed he had contacted doctors at Karen Hospital who were attending to the Deputy President. He further stated that owing to the condition of the Deputy President, he had not been able to access the Deputy President or talk to him. Senior Counsel then proceeded to cite Article 145.6, observing that although the Senate had opted to proceed by way of hearing the matter in plenary, and while Article 145.6 provides for the hearing of the matter by way of special committee, the provision obligates the Senate to accord the Deputy President an opportunity to be heard before a vote is taken on the impeachment charges. He further cited Rule 11 of Part 1 of the second schedule to the Senate standing orders, stating that in accordance with the provisions, the Deputy President had chosen to appear and be presented in these proceedings. Counsel for the Deputy President further submitted that the right of the Deputy President to be given an opportunity to be heard under Article 145.6b of the Constitution is not limited by the 10-day timeline otherwise provided for in this matter. In the end, relying on these provisions, counsel for the Deputy President requested that the Senate adjourns the matter to Tuesday, the 22nd of October 2024, to enable his client time to be attended to by his doctors. In response, counsel for the National Assembly, Mr. Gumbo, registered his sympathies to the Deputy President. On the other hand, he noted that the health matters are matters that are beyond human control. However, he noted that the matter at hand was one that was governed by constitutional timelines. Counsel further indicated that Article 145.6 of the Constitution applied to impeachment proceedings in committee and was not therefore relevant to the present proceedings, which had been convened by dint of Article 145.3 of the Constitution. Counsel observed that the dates for the hearing had, by Gazette notice, been set at 16th and 17th of October 2024. Council therefore went ahead to observe that His Excellency the Deputy President had robustly participated in the proceedings by filing detailed responses to the allegations as set out by the National Assembly and through various submissions made in the course of the hearing, including cross-examination of witnesses. Council then indicated that if any prejudice was to be suffered by the failure of the Deputy President to testify and be cross-examined, this would be on the part of the National Assembly, which had a legitimate expectation of testing the evidence of the Deputy President through cross-examination. Council then referred to the practice in the courts, including the Supreme Court, where parties are allowed to file respective submissions, and the advocates are then allowed to appear and highlight their submissions. Council argued that noting the Deputy President had filed detailed responses and had the opportunity to examine the witnesses of the National Assembly, the health status of the Deputy President, and the constitutional timelines, and borrowing the practices of the courts, the National Assembly was willing to forgo